If you live on Vancouver Island, you already know this feeling. You drive past a green hillside one year, the next year it's bare. And someone tells you it's private land, nothing can be done. That sentence is wrong because it's not true that nothing can be done. It's also not true that private property rights mean communities have no say. What I'm presenting today is part of the new Forest Act proposal, a legislative framework we're advancing for British Columbia. It's not government policy yet. It's a structural replacement for the current system designed to be enacted by the legislature. This video shows how that proposed framework would apply to private managed forest lands in BC, which are currently governed under the Private Managed Forest Land Act, the PMFLA. And yes, if enacted, this would change everything. Before I get into private land, here's a quick understanding of forest management on BC Crown land versus private land and what the new Forest Act does overall. Because one of the issues on Vancouver Island is that private land logging operates under different rules than for public land. Overall, the new Forest Act replaces BC's industrial volume-driven forestry regime with a system that starts from ecological limits instead of timber targets. Instead of asking, how much can we cut? It asks, what must stay standing to keep watersheds stable, communities safe, and forests functioning? It also incorporates community-based decision-making into law. So here's how things work right now. On Crown land in BC, the Crown owns the timber. Companies hold time-limited licenses, replaceable forest licenses, tree farm licenses, woodlots, etc. The government sets an allowable annual cut. Logging rights exist because the public grants them. On private land under the PMFLA, the landowner owns both the land and the timber. There is no Crown tenure or licenses. There's no provincially assigned AAC. Instead, landowners voluntarily enroll in the managed forest tax classification, and they follow lighter environmental standards overseen by the Private Managed Forest Land Council. Under the proposed new Forest Act, for Crown land, the Forest Act and Forest and Range Practices Act would be repealed. Public forest licenses or tenures would not automatically renew like they do now every 5 years. Licenses will expire at their renewal dates. That means the system will transition over 1 to 5 years. Private land on Vancouver Island is different. Under the new Forest Act, the PMFLA gets repealed. Private land does not transition through tenure reform. It transitions through regulatory and tax reform, which I'll get into. The separate requirements that currently exist for private logging end, and ecological standards and land use rules are brought into alignment with the broader public interest framework under the NFA. That means private managed forest land is no longer an industrial carve-out. Before we zoom in on private land, here's the broader shift. The new Forest Act restructures how forests are governed across British Columbia, public and private, around 3 simple priorities: ecological integrity, community-based decision-making, and local economic stability. Instead of managing forests primarily as timber supply, the NFA treats forests as essential public infrastructure because they regulate water, stabilize slopes, prevent flooding, and support biodiversity. Under the Act, all forest land, whether Crown or private, is managed through a spatial framework called Protect, Restore, Harvest. Protect means primary forests remain standing and unlogged. Restore means degraded landscapes are repaired through road removal, slope stabilization, hydrological repair, soil rebuilding, and other scientifically validated restoration methods. Harvest means logging occurs only on previously logged land within ecological thresholds using methods that maintain forest function and long-term productivity. The difference is not whether logging happens. The difference is that ecological limits come first. The logging fits inside those limits. Let's be precise about what the PMFLA currently does. Private managed forest land owners receive significant tax benefits, and they follow lighter environmental rules than for public land. And this is not abstract. On Vancouver Island, that has meant clear-cut hillsides above drinking water sources, logging on steep slopes, removal of forest cover in high rainfall watersheds, and little to no meaningful community input. And when residents ask for recourse, they're told it's private. Municipal councils cannot override it. Regional districts cannot regulate it. But here's the reality. Private property rights in Canada have never meant unlimited rights. You cannot dump waste into a river or build without permits or ignore zoning laws. Forestry should not be the one exception. The NFA does not eliminate private ownership. Land remains privately owned. What changes is the management framework. So what does the new Forest Act do differently? Under the new Forest Act, the same ecological constraints that apply on public land will be applied to private managed forest land. That means ecological limits apply to logging. Slope stability, hydrology, and habitat thresholds all have to be respected under the law. The protect, restore, harvest logic applies. Community-based oversight exists. Community forest boards are created under the Act to oversee management regionally. The Water Sustainability Act regulations are fully implemented. This matters enormously on Vancouver Island, where hydrology is critical. The NFA is not confiscation, it is regulation in the public interest. Exactly the same principle that governs lands in the Agricultural Land Reserve in BC. Now let's talk about taxes, because this is something that critics bring up. Under the current system, private managed forest lands receive property tax reductions. Those tax benefits were justified decades ago as a way to support stable rural forestry jobs. But on Vancouver Island today, large corporate owners dominate. Logs are exported, and communities bear the hydrological impacts. The NFA aligns tax benefits with stewardship outcomes. In order to receive tax advantages, landowners must meet ecological standards. Those that degrade watersheds lose the tax advantages. To maintain the preferred tax classification, landowners must meet ecological protection requirements identified through Community Forest Board planning processes. And that would include protecting wildlife corridors and sensitive habitat. They must meet reforestation success benchmarks, as well as road density and stream crossing standards. They must respect watershed disturbance thresholds and maintain a clean compliance record. That's not radical, that's basic accountability. The next question critics raise is predictable. Is this legal? Yes. Provinces regulate land use all the time. Zoning laws limit what private landowners can build. Environmental laws restrict what private landowners can dispose of. Forest practices can be regulated even on private land, especially when downstream communities face risk. The PMFLA already regulates private land and the rules about what they can and cannot do. But now there will be a new law. For private lands, the NFA changes the statutory framework. This is legislative reform, not expropriation. When it comes to logging, one of the biggest frustrations on Vancouver Island is powerlessness. Local governments can't intervene, and residents are told decisions are out of their hands, even if they're impacted by the consequences. Under the NFA, community forest boards will oversee forest management for local land and watersheds. Among other things, they will coordinate watershed scale planning across public and private forest lands, including logging and road building activities. identify watershed risk priorities, provide formal written input on high-risk proposals, and determine restoration sequencing and priority areas. Community forest boards include local residents and local Indigenous reps rather than company owners, like the current Managed Forests Council. The boards are supported by new structures within the government, including a new Ministry of Ecological Integrity, regional science panels, Indigenous knowledge panels, and restored forest ranger offices, which will take care of monitoring and compliance. There will also be a new Office of the Forester General, which reports annually to the legislature. Other changes under the NFA include local governments having a say. They get formal standing in watershed risk reviews, so they can flag concerns for drinking water, roads, and emergencies. Enforcement and compliance under NFA includes mandatory routine inspections, not just complaint-driven responses. Stop work authority is also included, and restoration orders are enforceable. Preferential tax classification is revoked for non-compliance. All of this is structural change. It replaces corporate monopoly control with publicly accountable governance. So what does this mean for Vancouver Island? No more liquidation of primary forests on private land for whatever primary forest is left. No more unchecked slope failures above communities. Hydrology-first planning in high rainfall watersheds, and a shift from volume extraction to ecological thresholds. Logging does not disappear, it changes. Selection-based, partial cut, or small openings are the methods that replace industrial volume-based harvesting. Where possible, the aim is continuous forest cover. Long-term productivity and forest function get restored. It'll take time, but this has to start somewhere. For years, island residents have been told it's private land, nothing can be done. That is not true. The Private Managed Forest Land Act is a political choice, and it can be replaced. The new Forest Act is another political choice. One prioritizes short-term extraction, the other prioritizes ecological integrity, community safety, and long-term stability. Change is possible. The law can be rewritten. The only question is whether we're willing to do it. If you want to read the new Forest Act framework or the new PMFLA Appendix, it's linked below. Everything is public and transparent, and it's available for you to read yourself. You know what the problem is, and now you've seen the solution. The only thing that determines whether this becomes politically possible is support. If you want this framework advanced, funded, presented, refined, and pushed into the legislative arena, support it. Donate below. Policy doesn't change because people are upset. It changes because people fund the alternative.